Hey everyone, it's Will Dungy and I'm back with my second video. Today I'm talking about Charlotte Farms Animal Sanctuary versus the Township of Berkley, docket number 009119-2025. It is an unpublished decision written by Judge Cimino. Judge Cimino is actually the judge I clerked for while I was clerking in the tax court. So, as I said, the taxpayer here is Charlotte Farms Animal Sanctuary, and they are seeking a property tax exemption under NJSA 54:4-3.6. Now, property tax exemption cases are one of my favorite types of cases. I think that there are a lot of creative ways for a taxpayer to seek a property tax exemption. Some are not so above board, and some are. Nonetheless, it takes a very skilled tax attorney to appropriately articulate a borderline case. So in this instance, Charlotte Farms has property that consists of farm acreage along with 2 residential homes on the property. And Charlotte Farms, i.e. the taxpayer here and out, would like the entire property to be exempt. So in these typical cases, it doesn't initially go to the tax court. Typically, the taxpayer needs to file with the assessor in the town where the property is, seeking approval of their tax exemption. Now, a lot of taxpayers get it wrong. They only file a very short application and only cite the specific statutes and say, because of that, I'm entitled to an exemption. However, when you're filing with the assessor's office, you really need to be as thorough as possible and treat it like you're almost filing with the tax court, because assessors, they're not going to go above and beyond to try and understand why you need a tax exemption. You need to really lay it out in front of them so that they don't need to look other places to figure out, what it is you're saying or seeking. So here they went to the tax assessor, and the tax assessor initially approved the farm acreage, but denied the exemption for the 2 residential homes. So upon the denial, a taxpayer is able to appeal the denial to the county tax board, and here they did that. However, when they appealed, the county tax board at the tax board hearing determined neither the homes nor the farm acreage were exempt. So the taxpayer filed another appeal directly to the tax court, and this is how we got here today. But instead of the township filing an answer to the appeal, or in this case the complaint to the tax court, the township filed a motion to dismiss. Now, in the facts that were included in the township's motion to dismiss asserted facts outside the 4 corners of the complaint. And so typically in this scenario, the motion to dismiss is turned into a summary judgment motion where the movement has to prove that the law is on their side and no genuine issue of material fact exists. So as evidence or as proof for them, the township provided certificate of incorporations for Charlotte Farms Sanctuary, as well as a certificate of formation for entity called Junk LLC. The municipality also provided photographs and several vehicles and dumpsters displaying 905 Junk LLC located on the property. The dumpsters were apparently just sitting on the ground and weren't being dealt with appropriately, or might have been an eyesore. Metal debris was also filled in one of the dumpsters. So the municipality township asserted that there was also a commercial lease agreement that governed the occupancy of the homes. These lease agreements indicated that rent was $18,000 per month, but it would not be due if the tenants satisfy a labor value agreement for the complete running and maintaining of Charlotte Farms. The lease agreement indicated the landlord was Sarah Pines, nominee for Charlotte Farms and Animal Sanctuary. Now, as I said before, maybe in my prior emails, the owner of the land is very important. And here, the name Sarah Pines got Charlotte Farms into a little bit of an issue, but ultimately that decision wasn't decided in this case. Now, Charlotte Farms countered the motion to dismiss, saying that the caretaker and their families reside on site and do not pay rent per the subsidiary labor agreement because they are required to be present 24 hours a day and to attend the needs of the animals, maintain security, and ensure property operation of the sanctuary. The taxpayer also asserted that no commercial operations occur at the site and the dumpsters hold large volumes of farm waste. In a reply, the township asserted that the matter is ripe for summary judgment in its favor. So the court looked at both parties' arguments, and it was clear to the court that the assessor's decision to allow the exemption in the first place is sufficient reason on why this appeal should go forward, and that no summary judgment motion or motion to dismiss will be granted at this time. Essentially, because the assessor thought that at least one portion of the property should be exempt, and then the county board thought that the other, that all the property should not be exempt, created a genuine dispute of material fact. And those issues have not been resolved yet because no discovery has happened. So there has to be discovery as to the basic issue as whether an exemption is appropriate. And the specific statute that the taxpayer is seeking an exemption on, it's a very long statute. It's only 2 sentences, but the portion of the statute says all buildings used exclusively by any association formed for the purpose and actually engage in the work of preventing cruelty to animals, and all buildings actually used in the work of associations and corporations exclusively for charitable purposes. So that is what the discovery needs to focus on, and both litigants need to determine whether the taxpayer here is obliging by that. And there are several case statutes that articulate, what a taxpayer needs to meet these thresholds. And at a bare minimum, the 3-part test for establishing an exemption requires the organization is organized exclusively for the charitable purpose or tax-exempt purpose. It uses the property for the charitable or tax-exempt purpose, and its operation and use of the property is not for profit. Also, there is a subsidiary issue in this case because the 2 homes might be derivatively exempt. And for property to be derivatively exempt, the property in question has to be used predominantly as an integral part of the operation of the exempt organization, rather than being primarily a convenience to the tenant. And 2, reasonably necessary, the property has to be reasonably necessary for the proper and efficient operation of the organization. And so here, because the tenant is the caretaker of the farms, you have to articulate why probably that tenant needs to remain on the property so that they can carry the farm and can carry out its goal of being the charitable entity that it is. And I can think of a few reasons as to why that might be the case, and I can think of a few reasons in support of the township on maybe why this is more convenience for the tenant. Nonetheless, it's going to be an interesting way to see how this plays out. Now, there's also a third issue. I touched on this before, but it's the nature and extent of any operations by that junk LLC I mentioned, and whether what type of for-profit activity might be occurring there. In addition, the ownership of the property, that issue, no one knows at this point who Sarah Pines is, nominee for the Charlotte Farms Animal Sanctuary. Does she own the property, or is this form of ownership kind of under Charlotte Farms Animal Sanctuary? And if so, what facts arise allowing that to be the case, and not Sarah Parnes simply owning this property outright? So, based upon all of the issues that I just outlined, the judge clearly denied the motion to dismiss, summary judgment, and this matter is going to go back for discovery, and I might be back with another opinion, hopefully resolving this case. If you like this case, and stay tuned for more videos talking about similar issues. Have a nice day. Bye.